Greetings, friends of liberty. As we say here in the age of reason, needs must if the devil drives. And so I must, unavoidably, be both open and direct with you today. Now I do find that, when my sovereign on occasion inquires as to my advice on the suitable length of his cuffs, the width of his neckcloth, or the cut of his tails, he and the royal tailor are most gracious in their openness to my sartorial suggestions. Similarly, I have every expectation that those Americans amongst us, known historically for your openness, shall, like my sovereign, listen when I again emphasize that America has a problem. I do not use that word lightly. It consists, directly expressed, in the violation of your civil liberties enforced by Titles VII and IX of your Civil Rights Acts of 1964 and 1991, growing legal tumors overwhelming more and more of your societal institutions. Wokeness, or its successor ideologies, will likely never be eradicated without their excision. The problem consists, moreover, not just in these two terrible titles, as harmful as they are, but in the relative American obliviousness to this harm. This is your greatest danger, since one cannot dodge an unseen harm. As the author himself says in the book we shall review, and I paraphrase, the present agreement in society generally for these anti-discrimination laws is so marked that it's questionable whether the Supreme Court itself could tolerate the enormous societal pressure on it if it attempted to invalidate them. And thus, the title of this book, Forbidden Grounds, the case against employment discrimination laws, in which acclaimed legal scholar Richard Epstein, law professor at the Universities of New York and Chicago, and Hoover Institution fellow, presents a series of devastating arguments destroying any plausibility that the employment discrimination laws in Titles VII and IX can actually work. In this book, exemplary for its extraordinary scope, clear reasoning, deft prose, historical coverage, and masterful analysis, Dr. Epstein divides his argument into 6 sections. In the first, Analytical Foundations, he begins by outlining some key insights against anti-discrimination laws generally. To start, though many of us may recoil at the thought, Dr. Epstein points out that there actually can be justifiable commercial, ethical, and thus societal reasons for discriminating according to the characteristics legally forbidden by the Civil Rights Acts. Take, for example, age discrimination. Would it be beneficial if condominium owners were allowed to discriminate by age? Since, for example, some may then exclude families with children whose rambunctiousness and unpredictability can pose a serious threat of injury to the elderly? Yes. But this, of course, the beneficial result of creating some safe condos catering to the elderly while others cater to parents with children remains in violation of the Civil Rights Acts, which, in their obtuseness, outlaw all age discrimination. In this exact manner, free societies best determine and reward rational discrimination on whatever grounds, and punish irrational. Free societies thus best overcome the presence of irrational discrimination by lowering the costs of providing goods and services, since you can group people together more efficiently, while also effectively maximizing the ability to serve everyone's needs and desires. What other advantages does freedom offer? To a significant degree, those of acquiring knowledge about others, thus reducing the company costs of searching for good people to hire of any race or sex. So let's say, for example, that an inner-city business knows that more blacks than whites go to democratically approved, inner-city, union-controlled public schools, which are often horrible. If a business can offer general intelligence tests to black candidates, it can determine whether, despite having been forced by the state to attend such pathetic schools, these black job candidates, nonetheless, may have a viable company future. But the Equal Employment Opportunity Commission disallows such generalized intelligence tests, making it harder to find such qualified individuals. so there's no freedom of search. In the second section, History, Epstein reviews the beginnings of Jim Crow law in the South, which laws were enacted to prevent free markets from operating. Integrated streetcars, needing only one railway car instead of the extra fuel and inconvenience required for hauling around two segregated cars, made more sense and naturally motivated everyone to pass the savings of lower fares on to their passengers, thus incentivizing everyone to be less racist. In other words, even racists are going to think twice if being racist makes their trolley fare twice as expensive. And that, incidentally, in a nutshell, is how you fight all irrational discrimination. As Epstein describes, precisely because free markets were working, Jim Crow laws were then enacted throughout the South, which prevented these more rational businesses and their more rational consumers from acting to eliminate racism over time. What was the legal rationale given for violating the freedom of contract of these businesses and consumers? With the Jim Crow laws, the police powers of towns and cities. The police powers being the constitutionally recognized coercive powers given to the police to regulate things like environmental nuisances of noise and smoke affecting others, and also in regulating how municipalities may treat contagious diseases which affect others. Under this power, laws were now drafted in the service of racists, preventing white passengers, for example, from sitting next to the alleged nuisance of black passengers. But then what about the Supreme Court and its celebrated judicial review of all laws to see whether they pass constitutional muster? And here we come, ironically, to one of the Supreme's worst decisions of all time, the famed Plessy v. Ferguson, where they enshrined and upheld using the police power to enforce segregated Southern railways and streetcars. The key mistake was in not striking down these laws which violated the rights of freedom of association and contract of railway operators and riders. In other words, using the police power to regulate smoke that actually harms others, understandable. But using the police power to regulate the alleged nuisance of a person of one color sitting next to another, that's illegitimate. And this wasn't the only mistake the Supreme Court made. In further cases, such as Berea College v. Kentucky, the state of Kentucky, backed again by the Supreme Court, prevented individual institutions, as in this case Berea College, from integrating their collegiate environment. Proceeding to the 1930s, Epstein shows how the collective bargaining allowed by the Supremes after 1937, again in violation of freedom of contract, increased the ability of racist unions, given monopoly privilege through coercive collective bargaining arrangements, to maintain artificially high wages by excluding Southern blacks from employment in the North under the Davis-Bacon Act of 1931. Moving to the third section, race discrimination. Here Epstein begins by describing firstly how Title VII departs from normal at-will employment law, in which you can be fired or leave for any reason at all, and now necessitates giving reasons for everything which better not be racist, sexist, ageist, or ableist. He proceeds to show, again contrary to modern expectations, how valuable the contract at will is, because it allows all of us to make use of the much greater knowledge than we have about ourselves to make or break contracts, which, if conditions no longer suit us, we may leave, while at the same time retaining our ability to make more complex contracts if necessary. And while it's true that the contract at will allows employers to capriciously fire employees, smart employers don't, since this gives them a bad reputation among both their existing and potential employees. Reputation matters in free societies. Secondly, Epstein continues by explaining the fundamental difference between treatment, and disparate impact, and how, as Gail Herod implied in her paper reviewed here, disparate impact, which we have now, is more deadly to the rule of law. He mentions the great difficulties in determining a racist motive. Legally, this is called joint causation, since a possible racial motive may be mixed with a secondary allowable motive for dismissal. He mentions the enormous increase in paperwork the law entails in order to record and examine every bit of possible evidence with regard to proving racist motives. He mentions how the law, in essence, violates the Equal Protection Clause by focusing only on minority rights. And finally, he mentions the enormous complexity, expense, and potential liability introduced when searching for and hiring new candidates. Thirdly, Epstein also points out that businesses will always adjust to these regulations in many subtle ways that the EEOC in Title VII can't control, as in moving the business from the inner city to the suburbs, with the resulting income loss to all those black inner city workers. In the next section, Part 4, Sex Discrimination, Epstein shows, in the same way that he did with our original example with age, how discriminating by sex can be beneficial as well. Men and women, of course, differ markedly, not only in their physical strength, their risk aversion and mechanical aptitude, but in many other important qualities. For example, a telephone company would likely have fewer female telephone line persons because women on average don't do that job as well as men, in the same way that men on average are inferior nurses. As he notes, however, the EEOC won't allow the reality of gender differences to affect its treatment. In other words, it tries to make us all believe in a fiction so that the employers will nonetheless be held liable if they discriminate rationally between men and women. Incidentally, the same applies to pensions, with Title VII giving women more money than they've put in because it assumes they only live as long as men. Of course, they live longer. Sex discrimination laws are also enforced with no regard to the preferences of the consumer. Epstein here gives an example of a ski resort he himself visited, which advertised male or female instructors according to customer preference, but which, in the case of female clients choosing female instructors, would be in violation. Clearly, the EEOC doesn't think that the customer is always right. In Section 5, Affirmative Action, Epstein notes the obvious truth, which many have pointed out, that the actual text of the 1964 Civil Rights Act nowhere authorizes either affirmative action or quotas. And in fact, the act never would have passed if it had. Nonetheless, the Supreme Court historically quickly ignored the text of the law and its history in allowing the racist treatment of whites and males now common throughout American institutions. In the final section, Newer Forbidden Grounds, Epstein demonstrates how whether a company should be allowed to use mandatory retirement ages or not as they wish. A case-by-case for-cause policy can be very costly, requiring extensive testing and information gathering about medical history and many other factors. So in some cases, it's just simpler for a company to say, everyone retires at 65, and they allowed that freedom. And if a still effective worker wants to work longer, he should have little problem convincing a new company to hire him again for a while. Finally, with employment laws dealing with the handicapped, Epstein again comes to the right conclusion: let markets decide. Let freedom reign. Forcing universal access for all private businesses in all situations to the handicapped doesn't make sense, since, like persons, some businesses are more able to deal with the handicapped than others. All in all, I'd give this book an A, only taking off from an A+ because he doesn't understand tenure correctly, which in reality is a kickback to the faculty of a portion of the monopoly profits that universities receive for state universities from their explicit governmental monopoly, and for privates from the many implicit subsidies granted by their various tax exemptions, like capital gains and property. In a world of market education, tenure as we know it today would not exist, its disadvantages vastly outweighing its advantages. In conclusion, this book, read in its entirety, will require serious engagement, but it will reward that effort with a magnificent and comprehensive understanding of a subject, given the ubiquity of anti-discrimination laws, of crucial importance to the well-being, not only of America, but Western civilization itself. With that promissory note, I bid you well and remain the Scarlet Pimpernel.